Thank you, Congressman Ellison and Mr. McFay and Chairman and members of the committee. Thank you for the opportunity to address your committee. As Congressman Ellison said, my name is Joel Green and I am with Upsher-Smith Laboratories of Minnesota. I'm here to ask for your support for legislation that will protect working people throughout America whose retirement security is imperiled by the Madoff fraud, including current and former employees of Upsher-Smith Laboratories. I urge your support for the legislation prepared by Mr. Ellison and Mr. McFay to extend SIPC protection to cover the losses of individual participants in pension plans, profit-sharing plans, and other qualified plans lost in the Madoff fraud. Upsher-Smith Laboratories is a family-owned pharmaceutical company. The company was formed in 1919 and has approximately 550 employees in the Twin Cities, Denver, and around the country. In 1974, our owners established the profit-sharing plan to share the profits with our company's employees, and beginning in 1995, the plan assets were invested with Mr. Madoff. Over the next 12 years, the company contributed over $8 million to the plan for the benefit of our employees. On December 11, 2008, Mr. Madoff was arrested for fraud, and approximately 615 of our current and former employees lost their retirement savings that had been in the profit-sharing accounts invested with Mr. Madoff. Our plan and our plan participants are representative of the average American workers whose retirement savings ERISA was intended to promote and whose investments SIPC was intended to protect. Of our 615 plan participants, approximately 550, that's about 89%, had contribution balances of less than $50,000. This plan covers the average American worker. Yet SIPC has stated that only a single recovery of $500,000 is available. This is because the plan's account with Mr. Madoff was held in the name of the plan trustee. But this was required by an administrative requirement imposed by ERISA that plan assets must be held in the name of the plan trustee and not in the name of individual plan participants. Our plan lost in excess of $8 million in contributions in the Madoff fraud. If one includes the false Madoff profits, that number would be in excess of $18 million. A single SIPC recovery of $500,000 will not go far to cover the losses of our individual plan participants. The administrative rule of ERISA requiring that plan assets be invested in the name of a plan trustee cannot be allowed to defeat the public policy behind ERISA to promote retirement savings of average American workers, nor can it be allowed to defeat the public policy behind SIPC to protect the investments of average American investors. For most Americans, their primary investments are held in their pension plans, profit-sharing plans, and other qualified retirement plans. If the administrative rule of ERISA is allowed to defeat SIPC protection for the losses of individual plan participants, then SIPC fails to protect the investments of the average American worker as Congress intended when it adopted the Securities Investment Protection Act and created SIPC. This in turn undermines the public policy of promoting savings and providing retirement security for average American workers through pension, profit sharing, and other qualified plans as Congress intended when it adopted ERISA. The FDIC offers a parallel for what we propose here. If a profit-sharing plan invested in its assets in FDIC-insured deposits, even though the deposits were held in the name of the plan trustee, the FDIC would cover each plan participant up to the FDIC limits. We have been asked by a congressional staffer in the spring whether it's possible as a matter of policy to extend SIPC protection to cover the losses of individual participants of pension plans invested with Madoff and not also extend such protection to individual investors of feeder funds who invested with Mr. Madoff. With great compassion for those individual investors and great compassion for Ms. Langford, we believe that the answer is yes. As a matter of public policy, a distinction can be made, though we of course support any relief that can be given to the individual investors in feeder funds. ERISA prevents individual plan participants from investing their retirement accounts directly in their own names. The situation differs for individual investors in feeder funds. They are not prevented by federal legislation from investing directly in their own names. Nor is their investment governed by the public policy of encouraging worker savings as embodied in ERISA. For these reasons, if a distinction must be made on a policy basis, we believe it is possible to provide SIPC protection for the losses of plan participants of ERISA plans, though again, we do support relief for investors in feeder funds. Thank you for your time and attention and consideration of this important legislation to extend SIPC protection to the claims of individual participants of pension, profit sharing, and other qualified retirement plans.